Okay, shall we resume? So the question to look at with regards to actual assignment is whether it's more like a transfer, which is where you go from A having a right against X to B having a right against X. Is it more like a transfer, or is actual assignment more like a declaration of trust, where you go from A having a right against X that they can use for their own benefit to A having a right against X and being under a duty to B? Okay, that's the question to think about with actual assignment. Does it really involve the transfer of a right from A to B? Now, one thing to notice is that it's very easy to make an actual assignment. You just have to make clear that you're immediately transferring the benefit of a right to B. You're immediately giving B the benefit of your right against X. That's all that A needs to do. You don't need X to consent. You don't need B to provide consideration. You don't need to give notice to X. You don't need to do it in writing. Okay? Now, this is what on the handout is called the Type 1 actual assignment, and this works in relation to existing rights. These are rights that A has at the moment. Okay? So if A has the right at the moment, they can make an actual assignment without using writing, without getting X's consent. Okay? And without B even providing consideration, although, as I said, the context we're interested in are the ones where A is basically selling the rights, so B will always provide consideration. So from the Brandt's case, you don't even need to use the term assignment. Doesn't even have to be addressed to B. And the Brandt's case shows you that. The Gorringe case is useful because it shows you that you don't have to notify X, and the crucial point I made before, that you are protected under a declaration of trust. B is protected if A goes insolvent. Crucially, the same is true. So you're protected under declaration of trust if A goes insolvent, and crucially the same is true with an actual assignment. If there's an actual assignment from A to B, B is protected if A goes insolvent. Okay? And the Gorringe case shows you that. So the actual assignment, in some ways it already looks a bit like a trust, because if you have an existing right, you can declare a trust over that right without X's consent, without B providing consideration, without needing writing, and B is protected in insolvency, which is also true under a trust. So there's already some close links between what you get under a trust and what you get under an actual assignment. Now, one way to tell the difference between a transfer and a trust that we talked about before is, does B get a direct right against X? Clearly they do if there's a transfer, but under a trust, no, because A is in the way. Now, the Brandt's case is an interesting one on this, because in the Brandt's case, B was allowed to win in a claim against X without joining A, but at the same time, the House of Lords made very clear that that shouldn't really happen. Okay? They said, strictly speaking, A, or their trustee in bankruptcy if they're insolvent, A has to be before the court when this debt against X is enforced. Strictly speaking, that should happen. Now, in the Brandt's case, the reason it didn't happen is because nobody had really thought of the point until it got to the House of Lords. And in the House of Lords, X said, oh, it doesn't matter, I don't mind. So X, remember these rules are there to protect X. In Brandt's, X said they didn't mind. And so it seemed a bit silly then if the House of Lords were going to say, no, we're going to throw your claim out because of this defect which X doesn't mind about. So Brandt's is a sort of funny case because on the one hand they do allow B to succeed in this claim without A being a party to it. And that makes it look like B's got a direct right against X. But at the same time, the House of Lords emphasises that B doesn't have a direct right against X, because strictly speaking, A should be there. Okay? So it's a little bit ambiguous. But if you look at the Robertson-Gill case, which is a more recent House of Lords one, Lord Collins in. Now that wasn't about equitable assignment, it was about a different type of claim, but they were attempting to draw some analogies with equitable assignment, and therefore Lord Collins looked at it. And he makes clear, he says, it's plain that other than the most exceptional circumstances, like in the Brandt's case, with equitable assignment, B can't proceed to judgment without joining A. Okay? And he explains why the circumstances were funny, exceptional in Brandt's. So it seems that the rule is, if there's an equitable assignment, for B to get the money, for X to be sued, A has to be a party. B can't just sue X directly. A has to be a party. Okay? And what happens when you make A a party? What B is allowed to do is B is allowed to sue A and sue X at the same time. But this is because what B is doing is B is suing A to force A to sue X. So strictly speaking, it's A who's bringing the claim against X. And this is just like in a trust. In a trust, B is allowed to use a procedure where B can sue A to force A to sue X. It's called the Van der Pitt procedure because of a case where they allowed it, called Van der Pitt. So if there's a trust, B can't sue X directly, but they can sue A and force A to sue X. And then you can bring two claims in one set of proceedings, which is handy. And that's what they're saying in Robertson-Gill. You can do that, but it's strictly speaking, it's not about B suing X directly. It's about B suing A to get A to sue X. Okay. And you might say, well, what's the difference? What's the difference between B suing X directly and B suing A to get A to sue X? Why bother? So people who like the transfer model, they would point to the fact that in Brandt's, B was allowed to enforce the debt without A being a party. And they could also point to the fact that Lord Collins in Robertson-Gill describes the need to join A as a procedural question. He says the requirement is a procedural one. And that, that might suggest, oh, it's not too important. Okay. So if you like the transfer model, you might say, well, B was able to win in Brandt's anyway, and it's only really a procedural thing. It's not really a big issue. But if you prefer the declaration and trust model, you can say, well, in Brandt's and Roberts, the general rule is very clear that B can't sue X directly. And it might actually matter that you have to sue A to sue X, rather than suing directly. And a good example of this is the Smith and Mannering case. Okay? So main wearing there, you pronounce that Mannering. Like in Dad's Army, if you're familiar with that. So, now again, this wasn't a case about equitable assignment, it was a case about subrogation. But again, the court, Lord Justice Carr, who is the brother of Judith Carr. Who's Judith Carr?
Actress?
Well, there might be one. Not the one I'm thinking of. Judith Carr. Literature. Children's books. Perhaps there's a children's book. Judith Carr. And she wrote The Tiger Who Came to Tea and the Mogg books and When Hitler Stole Pink Rabbit. And, Carr was her older brother, and he features a lot in the When Hitler Stole Pink Rabbit book. It's a good book. It's a very interesting book. And anyway, and he's quite cool as well, Carr, in lots of ways. in this case, which I think is a good case, what he was looking at equitable subrogation. Now, what happens with subrogation is you're an insurer and you pay money to someone who's insured, who's been a victim of a tort. Okay, so, you know, say somebody steals your bike or whatever and your bike's insured, so the insurer pays you. But if you find the person who did it, if you find the person who stole the bike, you get a right to sue them. But you don't need to sue them because the insurer paid you the money. It's the insurer who wants to sue them. So the law gives you a mechanism for doing that. It's called subrogation. And what that means is the insurer can sort of take over your rights against the tortfeasor, and the insurer can use those rights to win. Now, technically, procedurally, in these subrogation claims, the claim is brought in the name of you, in the name of the person who was the victim of the tort. So that's why all your tort cases have names like Stoven and Wise or whatever, whereas really it's the insurer who's suing. Okay, it's almost always the insurer who's suing. But technically the claim belongs to the injured party. It has to be brought in the name of the injured party. And the problem in the Smith and Mannering case was the injured party was a company that no longer existed. It had fallen off the company's register. And the insurer said, oh, well, come on, that doesn't matter. Just let us sue the tortfeasor directly. That was only ever a technical, procedural thing. Just let us sue. And the Court of Appeal says, no, you can't do that. It's like equitable assignment. The claim that is being brought is the claim of A. It's not the claim of B. So if A doesn't exist, you're in trouble. You can't sue X directly because it is A's claim that's being enforced. And he says, to contend, as counsel for the insurers suggested, that the problem is only one of form and not substance is untenable, as it would be in the case of an equitable assignment. Now, again, you could say, well, look, you know, that was technically about equitable subrogation. They were just using equitable assignment as an analogy. And if you prefer the transfer model, you could use Smith and Mannering a different way, and you could say, well, look, isn't it silly to say that B can't sue directly, because then you could have this problem if A doesn't exist. So you could use Smith and Mannering as an argument to support the transfer model. But certainly in the reasoning, Smith and Mannering supports the view that what's happening with equitable assignment is it's more like a trust than a transfer. You know, the diagram there on the right, there, rather than the diagram on the left. Are there any other differences? Well, one important one, I think, is if you're X and you don't know about the equitable assignment, nobody's told you about it, and you just go ahead and pay the money to A, like you originally agreed to do, then the debt is discharged. So if X, after the equitable assignment, and without notice of the equitable assignment, if X just pays A, like they agreed to do, B can't complain. Okay? B can obviously claim against A, but they can't complain in relation to X. So that's the second point on the handout there. If X hasn't received notice of the assignment, X can still be discharged from the debt by paying to A. Now, that is a difference, I think, between what happens with equitable assignment and what would happen under a transfer model. Because under a transfer model, the debt would now belong to B, and X could only be discharged from the debt if they paid B. But again, like the rule that A has to be joined, this is really about protecting X. I don't think these rules are technical rules. It'd be a mistake to see them as just matters of procedure or form. These rules are here to protect X. And the reason that equitable assignment works in that way is precisely to meet the concern that a transfer model would not protect X properly. Okay, so I think the declaration of trust model is a better fit for equitable assignment than the transfer model. And I said that back in 2008, and some people have said it since, in the Tam article, and there's the Edelman and Elliott article, the LQR article, where they say that point as well. Okay? But I wouldn't go as far as Elliott and Edelman, because or Edelman and Elliott, I forget which. What they say is that a declaration of trust and an equitable assignment are basically the same thing. They say an equitable assignment is just a declaration of trust. But I don't think that's quite right. I think there are still some differences. One thing we talked about are the fiduciary duties. That's potentially important. I don't think I'd really regard A as being a trustee in the usual sense, where they have all these fiduciary duties to be. Okay. Another example is something additional that B has, something extra that B has under an equitable assignment, which they don't get under a trust. And that is the power to discharge X's debt. Okay, it's the power to discharge X's debt. So if you have an equitable assignment, and then X offers to pay the money to B, X says, look, I'll pay you the £100, and B accepts, then A's right against X disappears. Okay? If there's an equitable assignment, what I'm suggesting is, like the trust model, with an equitable assignment, A keeps the right against X. So A still has that right against X. But with an equitable assignment, if X then pays the money to B, clearly A can't sue X again. So when A makes the equitable assignment to B, A is giving B the power to discharge the debt that X owes to A. Okay, this is quite important if you think about the position of X again. Because from X's perspective, if there's an equitable assignment for B and then X pays B, you can't allow A to sue X as well. That would be daft. Okay? So the way you explain that is to say that when A creates the equitable assignment, A also gives B the power to discharge X's debt to A by accepting payment. So what you have with the declaration of trust is, in one sense, it's less than an assignment, because it doesn't give B the right to accept a discharge of X's debt to A. So in that sense, a declaration of trust is less than an assignment. But in another sense, a declaration of trust is more than an equitable assignment, because you get these fiduciary duties on the trustee. So I think there is a difference between declaration of trusts and equitable assignments. Okay. So I think Edelman and Elliott thought they were agreeing with me, whereas actually they're not quite agreeing with me. But they're agreeing with me a lot more than anyone else has ever agreed with me. So I'm still grateful to them. But I think there is, and the reason this matters, again, you might say, look, this is all a bit technical, but we'll see next week why it really does matter. Because the courts have allowed parties, in situations where the contract says you can't assign the right, the courts